Hello and welcome to this Strategy Financial Training video. Now this is just a bite-sized training video and it's been created with those of you sitting your BA4 certificate exams in mind, because today's video is all about the nature of a simple contract, and this short video is hopefully going to serve as a way for you to understand the basic terms and ideas associated with contracts, as a way for you to continue your studies about contracts so that you get the exact score that you're looking for, which is of course a pass in your BA4 exams. Well, what we need to get us started in this video is a simple understanding of what a simple contract is. And the best way to do that is through a definition. So a simple contract is a binding agreement between two or more people that the law acknowledges and which sets out what they should or shouldn't do. So let's imagine a scenario. You're buying something from a shop. You pick something off the shelf, you walk over to the counter, you pay the shopkeeper, and then you walk out of this self-service shop. Now you've got no verbal exchanges really, you've got no written exchanges, but in this contract, one person has agreed to pay the selling price for the item, and the other has provided the goods that they have advertised. Now, even without a written or an oral agreement, there is still a legally binding contract between the shopkeeper, or the business rather, and the person has just bought the product. And so what we see there is, although when we think of contracts, I'm sure we imagine a piece of paper with some legalese written on it. Well, in fact, it doesn't necessarily have to be written down. And in fact, I'm sure you're all aware that some contracts can even be oral. So, let's move on a second and look at the idea of who is actually capable of making a contract. And what we should bear in mind before we begin is this really can depend on the jurisdiction of where the contract is being made. And in most of these jurisdictions, it's pretty much anyone over 18 can make a contract. And in some jurisdictions, sometimes it's possible for someone under 18 years of age. Now, as you would expect, if you have made a contract, you are legally bound to it. Although there are exceptions. Maybe one of the parties was suffering from mental health issues when they entered into the contract, so it wouldn't be enforceable. Perhaps one of the people that have either signed or agreed to the contract, suffers from a disability in some way. And so both those cases, they wouldn't be legally binding. So as we've said, we've talked about the idea of simple contracts. Now, simple contracts just mean they're the most common kinds of contract. And the most common kinds of contracts are the ones we've already mentioned. They are either oral or they're in written form. Now, specialty contracts are more special than simple, which is why they're called that. And these are contracts that are normally made by deed. And deed is something we're going to come on to in a bit. And they're normally signed and then delivered agreements that is normally used for some important transaction like the ownership of property or legal rights. So you can see I've just put on screen a little bit too early there the idea of a discharge of contract. And this is the term used that when there are certain circumstances, the contract can be brought to an end. And so as you'd expect with the word discharged, when a contract is discharged, each party is freed from the obligations that were set under the contract. So there we go. That's three terms that are worth remembering. Simple contracts, the most common. Oral or written contracts. Then we've got speciality, which are normally made by deed. And then finally, another term or another terminology is discharge of contract, just when the contract is brought to an end. So what we're going to do now is look at some elements that are required to make a contract valid. So the first of those is the form. So for a contract to be valid, the correct form must be used. So if I were going to sell you a house, would you accept the transaction was complete if I had just shaken your hand? You paid me the money, I shook your hand and said, right, that's it, I'm off. Would you be happy with that? No, probably what you'd want for a sale of property or a sale of land, as we've already said, a speciality contract, which in this case probably would be a deed. So you've got to make sure that for a contract to be valid, it takes the correct form. The next element that's required is terms. And this means that the terms that are used in the contract must be appropriate. Now, it's not so much the terminology, it's the fact of the content, what the terms are actually expressing. So if I give you an example of an inappropriate term, to make the idea of an appropriate term a little clearer, an inappropriate term would be one that encouraged too much risk or too much loss. So let's imagine a contract. There's another contract that you might not be willing to sign. Now imagine we're going to sign a contract together, and I've asked you, and you're going to sign a contract that says you are going to tightrope across the Grand Canyon just to see if you can do it. Now, that's an inappropriate term because I'm encouraging, or you're exposing yourself to too much risk. Tightroping across the Grand Canyon is a pretty difficult thing, okay? So it would be inappropriate for a contract, and it would make it invalid. Consent, of course. So if one person involved in the contract gives false information, as you would expect, it could affect the validity of the contract, because what's happened here is someone has misrepresented some area of the contract. So imagine I'm going to sell you another car now. I'm sorry, I'm going to sell you something else. I'm going to sell you a car, and I didn't actually own it. So what I've done there is give false information. So I've entered into misrepresentation, and now the contract is invalid because the car wasn't mine to sell. So there we go. There's the car on screen for you. And then we move on to legality. Now, a contract can be deemed invalid if it's illegal, in the sense of the terms that it's setting out would lead to illegality, or perhaps that it would lead to an area that's contrary to some kind of public policy. So, imagine now I'm an assassin, okay? And you want me to take care of someone for you. It's not really appropriate for you to give me a contract because, of course, the deed that I'm carrying out is illegal. So, of course, the contract would be invalid. So, sorry, if I didn't kill that person, you wouldn't be able to take me to court, I'm afraid. It's an invalid contract. And the final element of illegality is capacity. Because we've kind of mentioned this already with people suffering from mental health issues or age issues, because not everyone has the capacity to form contracts. For example, in the UK minors, and minors are people under the age of 18, aren't able to enter into certain contracts that would get them a loan or a credit card. So if someone under the age of 18 had done that, of course, the contract would become illegal. So we're kind of seeing in the terms of age, we're kind of seeing a kind of crossover between capacity and consent, aren't we there? Because someone's maybe giving false representation. But even if they're not, if they're saying I'm 17 and you still sign the contract with them, then yeah, that's still an invalid contract. Okay, so there we go. We've got our 5 elements: form, terms, consent, legality, and capacity. They're all required to make a valid contract.
all of them. Okay, we're going to zoom out now, and we're going to look at something called, well, I brought this up earlier, we're going to actually explore the idea of deeds in a bit more detail. So I just want to give you some examples of when deeds are used. And we've already talked, haven't we, about transfer of legal estate, so home ownership, land ownership, long-term leases. So you'd use a deed if a lease was to be used for over 3 years. And with patents as well. So when you're patenting a product, a deed would be required and suitable form of contract. So we just go back here very, very quickly for one of those things. And again, we'll zoom in here. The form. For the 3 things I've just listed, the form of the contract should take a deed. And here we go. Here's a proper written definition. It's a form or written agreement that is created using set rules to ensure that there can be little doubt that the agreement was indeed made. So, we can see from the definition that a deed has to be in writing. It has to be signed by both parties. That makes sense, doesn't it? Otherwise, it just wouldn't mean anything because you wouldn't be able to tell that someone had agreed to it. It also has to be attested, meaning that perhaps it has to be witnessed by independent parties to show that the people that are the people that have signed are the actual people. So we can tell actually that I've not gone, I'm pretending to be someone else so I can buy a house. And it should also indicate on its face that it is a deed. Now, unfortunately, deeds don't have heads. This just means on the front of the copy, it should indicate that it is a deed. And it should be delivered, formally given to the other parties in the deed. So there we go. Now let's have a look at the idea of a covenant. And covenants that are things that sometimes form part of deeds, but they also can stand alone. And it's an agreement that offers a solemn promise. Oh, that sounds very grave, doesn't it? And as I said, can be part of a deed or can be independent. So let's have a look at an example. And we've got Company A taking out a loan. And now what they may do is promise not to take out any other loans until they've paid this one off, giving the person that is giving them the loan or lending them the loan more confidence that they are going to be able to pay it back. So the covenant in this area is the promise not to take out another loan. I'm sure, I don't know how many of you have leased or anything like that, but often in a lease document, the landlord may promise to carry out certain work on the property during the terms of the lease. And again, that would be a covenant in the deed of the leasehold, okay? So there we go. That's a solemn promise of a covenant. And as you can see, I've just put on screen the corporate capacity to contract. And then we're going to look at written contracts. But firstly, let's stick with corporate capacity. Now, have you heard the term capacity so far in this video? Well, yes, you have. And can you remember what it was in regards to? It was one of the 5 elements required to make a valid contract. And in that sense, we were talking about capacity in personal terms. We gave the example, I don't know if you can remember, of a minor entering into a contract regarding a loan. Now, in the UK, that is illegal, so they do not have the capacity to enter into contract. And it's a very similar thing with corporate capacity. It's talking about the legality of, or the ability of, a contracting party to enter into legal relations. And there's one factor that decides whether a company has the capacity. And until 2006, and this is in the UK, all companies were required to spell out their objects, or rather the legitimate range of tasks for their businesses. So imagine if you were a company and you said, well, my objects or our objects are to create software. Now, if a company acted outside of that remit, it was considered invalid, or, ready for a little Latin lesson now, ultra vires. Now, ultra vires means beyond the powers. Now, of course, this clause, as you can expect, reduced the capacity, or reduced the flexibility, rather, of companies to do business, and so was removed. So, what I want you to just take, the point I want you to take away from this is the company must have the right to enter into a contract for it to be valid. Okay, so there we go. That's corporate capacity to contract. We're now moving on to written contracts. And we've said that some contracts can be oral, some can be written, but written contracts have to be written in order for them to be enforceable. Now, we use the UK as an example again, hence why we have the Union Jack on screen. So, for example, we'd read a written contract when we were transferring a share in a limited company. We would also need a written contract if we were to sell or dispose our interest that we had in a land promise to transfer title at a future date. We would also need a written contract for consumer credit and hire purchases. And all those contracts would need to provide the information required by the Consumer Credit Act of 1974. You would also find written contracts of bills of exchange, checks and promissory notes, and because all of these promise to pay for something at a later point. We would also need a written contract for assignment of debt. So imagine I owe you £20. Now you agree to assign that debt to your friend. Now, assign means just to pass over. So now I owe your friend the £20. Now, for that to be legal, you would need to have that in writing. Otherwise, I'm not going to pay your friend. I'm just going to put it out there. And the last example of when we need a written contract is with a guarantee. Now, a guarantee is an example of a contract which can be made orally, but isn't legally binding unless it has been evidenced in writing. So it can be made orally, but for it to be legally enforceable, it has to be written down.
So there we go. That's everything that you're going to need to know on simple contracts for your BA4 exam. Good luck with your revision. And of course, if you want any more of these bite-sized videos, be sure to like this video or subscribe to our channel. Thank you so much for watching and good luck for BA4.